No court has ever done what the plaintiffs are asking you to do.
But the Massachusetts Supreme Judicial Court decided that the plaintiff's consent was enough to authorize release of their deceased brother's emails, and that federal laws protecting the privacy of users of electronic communications don't prevent Yahoo from releasing the email content. Yahoo and its new owners continue to make constitutional arguments that digital assets are different from other property in the estates of disabled and deceased people.
People have an expectation of privacy protected by law and the Constitution against everyone, including their own estate administrators, when they store things online in an account and provide a password that they don't share. That is a constitutional expectation of privacy.
Yahoo appealed to the U.S. Supreme Court, hoping to overturn the Massachusetts decision that had allowed disclosure of email stored by a user who died without a will or any other indication of actual consent. Facebook, Google, and Dropbox also wanted to join in the arguments against allowing access to accounts of deceased users. Yahoo's petition was denied by the U.S. Supreme Court, but the Massachusetts litigation continued. To help people avoid these disputes over access to digital assets, most of the states have passed a uniform law that explains how a will, power of attorney, or trust can grant consent to access digital assets. The revised Uniform Fiduciary Access to Digital Assets Act, RUFADAA, has 3 levels for disclosure of digital assets. First, you can use an online tool provided by the custodian of the asset that allows them to disclose or not to disclose all or some of the digital assets that they are holding. Google and Facebook are custodians that have these online legacy tools. The online tool overrides any direction in a will, trust, or power of attorney document. If you use the custodian's online legacy tool, that tool will control. Any other instructions become irrelevant to the custodian. Second, if you have not used an online tool, instructions in your will, trust, or power of attorney document control the digital asset. In the legal document, the user may allow disclosure or prohibit disclosure. And finally, if a user leaves no instructions, the custodian's Terms of Service Agreement, TOSA, will decide any access to the user's digital assets.
Is it not true that the terms of service say we can destroy all of these documents and there's nothing you can do about it?
The terms of service do say that.
Okay, because you have unwittingly agreed to it?
I think Yahoo's perspective is tomorrow they might want to shut down the service. It's a free email service. They offer to 1 billion people. And if tomorrow they could no longer offer that service, they would not run for 30 years an estate administration system. They would shut it down. And their terms of service allow them to do that.
The arguments over Yahoo's Terms of Service Agreement continued. The Massachusetts SJC sent the family back to probate court to argue whether Yahoo's TOSA was an enforceable contract that bars access to the emails. The Terms of Service Agreement controls if the user leaves no instructions. But if a will, trust, or power of attorney document does include the fiduciary power to access an account, RUFADAA says that the custodian shall disclose the content of electronic communication to the personal representative of the estate. The fiduciary provides the custodian with copies of the will, the trust, or POA document, along with evidence of the fiduciary's authority, such as probate court letters of authority or an affidavit certifying the power of attorney. We can include this legal authority in your estate plan, so the person that you name in your power of attorney document and the personal representative named in your will to represent your estate will have access to your digital assets.